Yeah, yeah, yeah. Roberta in the truth zone, mic hitting raw. Spotlight shining, she exposing the flaw. Debunking the myth, breaking their facade. This is Glass City, respect the squad. On these NYC blocks where the skyline flex big. Roberta Glass slicing lies with a truth rig. Innocence frosters, your stories unravel. She's a map through the madness of gritty gravel. Glass don't bend and facts don't break. She's a storm that's called, you feel the quake. Exposing tales stitched with crooked seams. Justice in the lens, shattered fake dreams. Screams about killers, painted heroes in disguise. She burning propaganda with fire in her eyes. No glamour for the guilty, she call it straight. She backs victims, the voice stay away. Stats and receipts, no spin, no clutter. Cold cases whisper, she cuts through the mutter. Truth's her tempo, don't confuse the beat. She's standing for the real while you taking a seat. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time to play. She's glass hard, break the false and save the day. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time to...
I am back again, William. Hello. Hello, William. Hello, Audrey. Thank you for moderating. Hello, Susan. This is the charge conference, meaning the lawyers are going to work out with the judge how they're going to instruct the jury and how they can consider the evidence that they were presented in the trial of Kouri Richins for attempted murder. Utah uses a little bit different words, but this is essentially what these are the charges, and assorted fraud charges. So this isn't a particular, I mean, I'm just going to be honest with you guys. This is not something that fascinates me watching in trials. My friend Tony Natale, who I met going to the Nexium, all the early hearings in the Nexium, the cult of Nexium, I'd really call it, case. You know, there's a ton of, there's like a lot of defendants in that case for cult-related crimes, and they all pled guilty one by one, including actress Allison Mack. But my friend Tony Natale finds this fascinating. She also loves jury selection, something which, when I've gone to, it's just, I find it hard unless you know you're not given the questions the prospective jurors are answering these high-profile cases. It's hard to know. I didn't find that particularly interesting, but Tony Natale loves that too. So I think of her with this kind of stuff. So hopefully it'll be more interesting than usual. We know that there has been a great deal of back and forth. I don't know if I'd call it animosity, but definitely the defense has pushed this judge and argued with this judge more than we normally see in trials. So we'll see how it goes. This is what we're looking at. Court TV says they're starting in about 3 minutes. So while we're waiting, let's take a look at some of Carmen Lober's testimony, shall we? This is the housekeeper for Kouri Richins, who is the middle woman. So Kouri Richins went to her looking for pain-killing opiate drugs, and then came back to her after February 14th. That's the attempted murder charge, where prosecutors allege Kouri Richins poisoned a sandwich she got from a diner on Valentine's Day, poisoned Eric Richins. Eric Richins told his friends his wife was trying to poison him, and they all laughed. Piece of evidence I find very strange in this case. I don't know about you, but here's Carmen Lober in the minutes we have waiting for the charge conference to start.
Thank you. Please have a seat.
Please have a seat. When you're comfortable, please adjust the mic so it's Mr. Bloodworth, please proceed.
Thank you, Your Honor. Good afternoon, ma'am. I understand the defense has some additional questions.
Ms. Lewis.
Good afternoon, Ms. Lober.
Good afternoon.
Has anybody spoken to you about why you have been asked to come back today?
My lawyer told me I was getting recalled again today.
And were you told why you were being recalled?
No,
Okay. So nobody's talked to you about
no.
what we're going to go over?
No.
All right. I just have a few questions for you about your probation that you've been on since May of 2023 when you were released after all of your interviews with.
So she doesn't really have questions about her probation. She wants to highlight to the jury that she violated her probation in a bunch of different ways. And here's where a really good example of why telling the truth is always the best way on the stand. You don't get away with very often fibbing on the stand. She said she was at a concert. She bought drinks, but she bought alcoholic drinks for other people, but she didn't drink them. But then she told her probation person she drank them. She said that she left the concert early, but she didn't make it in time for curfew. I mean, if you're going to not make curfew, you might as well stay for the whole concert. If you're already, I mean, it doesn't make any sense to leave early to come back if you're still going to violate curfew. Doesn't matter if you violate curfew by 20 minutes or 2 hours. I don't think it's going to really matter by how many hours you violated it.
Detectives O'Driscoll and Detective Maynard, okay?
When I was released from Wasatch
Jail.
County?
Yes, when you were released from Wasatch County Jail, and then you were placed on probation.
Yes.
Okay.
And Commander, yes.
All right. All right, so when you were released, and I think we've already talked about, but just for some background, your probation was transferred to Summit County, right?
Yes,
And Detective Maynard became your probation officer.
correct.
And you said that you texted him every day while on probation?
Yeah, sometimes I'd forget a couple days.
Okay. But every day from then, like through today?
Yes,
Okay. Did you text him about everything about your probation, like your work hours and
yes.
everything was through text?
Sometimes phone calls, but yeah, he had my work schedule through text, mostly texts.
Okay. And would those texts be available either on your phone or on his? Do you know?
They should be, yes.
Okay. All right. Now, when you were when you were released and you went on probation, you signed a paper acknowledging what your conditions on release would be, correct?
Yes.
And that, well, actually, Katie, can you pull up Defense Exhibit 3014 for the witness?
So just an update for those that don't know. Today is this charge conference where they'll decide on how the judge will instruct the jury and how they can evaluate the evidence that was presented to them in this trial. Monday, closing arguments. Going to be very curious. It's very important, I think, for the prosecution, more than the defense, to pull together all the evidence. The jury was shown a lot of evidence and asked to read a lot of these text messages. So this is a rare case where text messages were not read out loud by law enforcement. or say someone else in the court officer, someone else. They're read by they were just shown, and the jurors were asked to read them silently to themselves. Now, I think it really gets not talked about very often what hard work it is to listen to a trial all day. When you're at home, if you miss something, you can go back and watch it, right? You can say, "What did they say there?" And you can go back. In court, if you miss something, it's missed. You just missed it. There's no going back. There's no watching it. Again, so you're listening really intently and for long stretches of time. Sometimes listening to sometimes very dry testimony. And I think most jurors take their job very seriously, but the reason we have 12 jurors is every juror is going to miss something. Some jurors are going to miss more than others. Some jurors are going to misunderstand the evidence. All that, it just takes a big toll on you. It's exhausting. I think it's really important for the prosecutor in this case to pull together all of the evidence. There's a lot of evidence in this case. And really make their case and say, this is what this is our theory of the case. It really wasn't very clear in opening statements, which is not the time to argue. Closing arguments is the only time they can argue their case. And pull it all together for the jury. And they should think about what kind of arguments a skeptical juror, a juror who would want to acquit, would think about. And this is their time to argue why they shouldn't acquit Kouri Richins, why they should convict her, and what the evidence showed, and how they met their burden. This is their time. I think they should be hopefully working all weekend on this closing argument. I would think Mr. Bloodworth would give it as he gave opening. It's been really the prosecutor who's questioned witnesses the most. Oh, we're just getting some sound from the cord here, kind of going in and out. So we're just waiting for this to start. But I think that closing arguments are going to be really important for the prosecutor if they don't want acquittals. I mean, we're looking at, from my point of view, and obviously innocence fraud is my area of interest, it would be a very rare jury that wasn't propagandized with decades and decades of innocence fraud media. On Netflix is so ideologically aligned. I mean, they've let the Innocence Project just put up their own propaganda in the form of what they call documentaries, what I'd call advocacy pieces for their cause, LOL. And so what we're hearing from lawyers is that jurors want more and more and more evidence to convict. And I've shared with you, when I was a juror, we had it wasn't a real iffy case. It was 11-1, the first 11-1 guilty, first vote. But after other people on the jury turned the one person who really didn't understand the evidence that was presented in the case, misunderstood a lot of important evidence. One young juror said, well, there are a lot of wrongful convictions, but this isn't one of them. As if there are tons of juries that are just convicting just to convict, sending people to prison for years on a hunch and feel that the state really hasn't met their burden. Like, that's regular. So I'll just tell you a little bit about the mindset. We've talked about the CSI effect, how more and more juries want high-tech, I don't like high-tech, like forensic stuff. I don't think there was really too much of that involved in this case. It's a real solid circumstantial case. Will that sell? So I think so, but don't know. Circumstantial cases are some of the strongest cases. Because there's so much evidence to debunk. And bit by bit, it all stacks up and creates a very clear picture of what happened. I think I think what the jury's going to be talking about most in this case is Kouri Richins' own statement that we heard her phone calls were taped. Kouri Richins' handwritten statements in the walk the dog letter, in her diary, the body cam footage, her statements on the body cam footage that contradicts much of what she wrote, or some of what she wrote. I don't know much, but some of what she wrote in her notebook. You can call it a diary. I don't know. But to me, it looks like the defense is very worried. They didn't put on a case. But I don't think that this wasn't a great investigation. And there would definitely be elements that, as a juror, I wish they had. For example, some piece of like a cup, a plate, something that was actually poisoned that was found in the house, or traces of fentanyl. But no drugs were found in the home. I mean, we basically heard the defense's closing argument in the cross-examination of Detective O'Driscoll, where he was asked, no drugs were found in the home, no murder weapon. He said, well, drugs were found in Eric Richins' stomach. I was like, good answer there, Detective O'Driscoll. Perfect answer. But I think that's what their closing argument is. That's going to be like this. That's going to be the basis of their closing argument. How's everybody else feeling as we're waiting here? Let me just make sure that we're not behind. Just gonna, yeah, nope. Just waiting for this to begin. Hey, Riverdale. Long time no see. Hey, Tater. I thought I saw Maestro somewhere. Popped in and out. Yeah. I would say by the numbers, other people also find these charge conferences not the most fascinating. I am in the house. So we're just waiting for this to start. Should we? I don't know. Let's see. I don't really want to get too deep into something else, but I can. If this goes on and on and on, it should start any minute. Yeah, this is only about a couple minutes, so maybe we can watch some of this. I'll keep an eye on the charge conference. This is Kouri Richins' housekeeper. This is her. She came back. It was the return of Carmen Lober. She came back for additional questions from the defense.
County jail, and then you were placed on probation.
Yes.
Okay.
And Commander, yes.
All right. All right. So when you were released, and this is, I think we've already talked about, but just for some background, your probation was transferred to Summit County, right?
Yes.
And Detective Maynard became your probation officer.
Correct.
And you said that you texted him every day while on probation?
Yeah, sometimes I'd forget a couple days.
Okay. But every day from then, like through today?
Yes,
Okay. Did you text him about everything about your probation, like your work hours and
yes.
everything was through text?
Sometimes phone calls, but yeah, he had my work schedule through text, mostly texts.
Okay. And would those texts be available either on your phone or on his? Do you know?
They should be, yes.
Okay. All right. Now, when you were when you were released and you went on probation, you signed a paper acknowledging what your conditions on release would be, correct?
Yes.
And that, well, actually, Katie, can you pull up Defense Exhibit 3014 for the witness? Can you see that?
She
There's
will in
nothing
just a
there yet.
moment.
Okay.
There you go.
Okay, now it's there.
And do you recognize that as your conditions of probation that you signed and agreed to?
Yes.
All right. Your Honor, could we I'd move to admit 3014 and publish it?
Objection, Your Honor. Hearsay.
These are being admitted to show what Ms. Lober understood, correct, Ms. Lewis?
Right.
Okay.
Correct.
Overruled. 3014 is admitted for the purpose of showing Ms. Lober's understanding.
Okay. And you signed that paper agreeing you would follow those conditions. Is that true?
Correct.
Do you want me to publish these?
Oh, yes, I said that.
Okay.
Sorry. But since May of 23, I mean,
I thought they did I don't know why they brought her back for this. She already came off as a little bit of a withholder, if not a liar. I mean, this bunch of questioning just underlined that point.
violated these conditions. True?
I don't recall what you mean by that.
Have you violated any of the conditions that you agreed to since you signed that paper?
Which one do you know?
You haven't violated any conditions?
The weapon one? Is that
I'm
the one
sorry,
you're talking
what?
about? The weapon one? Is that the one you're talking about?
Yeah, the weapon one, the one you were in jail for and almost did 7 years on. Yeah, that charge. You violated a bunch of them. I mean, she says no before she's sure. I mean, it's like a nightmare witness. This is my nightmare to have a family member murdered and then to have to rely on a witness like this
I'm asking
for justice. Luckily, they don't have to totally rely on her word.
you, did you violate the weapons condition?
If there was a weapon found in my room when they raided it, yes. If that's what you're meaning.
Was there a weapon found after you signed these conditions?
Yes.
So you violated that condition.
Yes.
All right. You also violated the alcohol condition, correct?
If you're talking about where I went to a concert,
That's correct. That's what I'm talking about.
yes.
All right.
My-
So, and that was in November of 2023, correct?
I'm not sure. The day of the concert, I went with a bunch of friends.
Okay. Could we just show the witness defense exhibit 3010? And actually, you violated in October of 2023. Is that correct?
Spoiler alert, she violated her probation by going to this concert and drinking. Just check out, let's look at some of these. So Court TV's chat and Law and Crimes is notoriously pro-defendant. But here we have Katie, meaning Eric's sister, is a narcissist. Who are these people? Who are these people with these personal hatred? Is Katie on a witch hunt? These personal hatred towards the victim's family. There's no hair follicle test, so it's a moot point. I wouldn't even consider. I think the walk the dog letters make sure you destroy. I think so too. Because her letter says make sure you take notes before you walk the dog. Yep, I agree with you. Guilty. I agree. I think they'll decide within 2 hours or less. Yeah. I'd be surprised if she's not convicted, but you just don't know. The pill bottle and not searching the truck means the state messed up. Really? The drug dealer was getting his drugs from someone else. How does he know what the hell he was getting from that person? Exactly. We have to look this weekend at we got to go back and look at Robert Crozier's, the drug dealer's testimony. He was he's a great example of a witness you don't trust. He just seems, I mean, he basically said that he told the state things that and signed off on things that were incorrect. Like you see his initials there. He says they wrote that down wrong. Really? But you signed off, you initialed it? Seriously? Okay, not guilty or hung jury, calling it now. Birdie Love. Remember Birdie Love, if she gets convicted, that's being wrong. If she gets a not guilty or a hung jury, guilty, 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 guilty. Josh agrees with Birdie Love that she's going to get acquitted. Maybe. I don't know. Who can predict a jury? Kouri, I mean, if Kouri Richins isn't guilty, then, I mean, what are we going to do? Just trials of people who are on camera doing the crime? And not even. Sometimes when they are on camera, they get acquitted too. Thinking of that California rapper case I covered. That was ridiculous. All right. I guess we can watch a little of this since it's more interesting than watching a seal on the wall.
Okay. I'm sorry. So October of 2023, you violated your alcohol condition, true?
I went there with a bunch of friends, and my buddy who bought me the ticket, I asked him if I could pay him back. He said, no, you could just buy the drinks and snacks.
All right. And you
Okay, hold on one second. Let me just reshare my screen. That's what we're looking at over here. Let me just refresh this. There we go.
This detective did.
and you admitted to him that you drank the alcohol,
I
correct?
had told him I was there with it, yes.
You said you consumed it.
No, I did not. I don't recall the time I consumed it, no. I had bought the snacks and beverages for,
Would you look at what's in front of, actually, Your Honor, can we just publish this now? I'd beg to admit. for
Objection,
impeachment
Your Honor.
purposes.
I think
Not- here.
hearsay,
Hearsay, yes.
sustained.
All right, I want you to take a look with the line that is,
Can't read it.
thank you, highlighted. I was going to count it. But the line that is highlighted.
Yes, I see it.
And what does that refresh your recollection as to what you told Detective Maynard?
No, I don't recall, but if it's there, I guess so.
So you did tell Detective Maynard you actually drank alcohol, correct?
I don't recall, but if it's there, I guess so.
Okay. So if Detective Maynard said that you admitted that to him, that's true.
Yes, the chief. Yeah,
All right.
he said it. Yes.
And in fact, you also violated your curfew too, correct? You had a curfew, isn't that true? Let me back up. You had a curfew, correct?
Yes.
You had to be home every night by 9 p.m.
Yes.
And you violated that also when you went to the concert, correct?
I don't recall if I stayed the whole concert. I did not stay the whole concert. I left early.
So
I was home at 9 o'clock, probably not exactly at 9.
So you don't admit that you violated your curfew.
Yes, I do.
You did violate your curfew.
Yes, but I
Okay.
said I did not stay the whole concert.
What does it matter? You violated your curfew. You didn't get it in time. And the better way to say it is I tried to respect my curfew. I left early, but I still ended up being late. Unfortunately, I violated my curfew. But the problem is it comes after her getting busted for lying about the alcohol. I mean, you wouldn't tell your probation officer you drank alcohol if you didn't drink it, right? I just bought it. Well, you can't purchase it. I mean, she didn't say, well, I got in trouble because I'm not allowed to purchase it. She said, I told them I drank it. Oh, yeah. Nightmare witness.
Okay. So the reason that you were
Okay, we just saw the hey, Maestro. We just saw the judge's head for a second. Shout out to Marie for sending me this image. That's the judge bringing me chicken soup. A very glamorous chicken soup. Like busted up ankle, fractured ankle. So there we go. Waiting for this to start. Looks like it's going to start any minute. I'll see you guys in the comment section. I'll be listening.
500139, State of Utah versus Kouri Richins. Counsel for the state, Mr. Bloodworth and Mr. Burmester in the courtroom. In the courtroom is Ms. Nestor with defendant, Kouri Richins. Participating via WebEx are Ms. Lewis and Mr. Ramos. Let me just provide a little context for where we are at the moment. I have given an honest try to updating the previous proposed set of jury instructions to reflect some events that occurred during trial, to reflect some, though not all yet, of defendants' proposals received by the court this morning. I've also provided a working copy of a proposed verdict form. This will be an iterative process. We need to go page by page. I expect I'll need to take breaks from time to time to consider the substance of your arguments. Let's just take it one step at a time. Mr. Bloodworth, Mr. Burmester, anything general before we begin?
No, nothing
Okay.
general.
Ms. Nestor?
No, Your Honor.
All right. So may we go by page number, working off of the draft that the court just provided to counsel. Pages 1 through 14 are the opening instructions that the court gave prior to opening statements.
Right.
Yes.
Any objection to including those in the closing instructions, Mr. Burmester?
No.
Okay. Ms. Nestor?
You want to reread them?
No.
Oh,
I'll
good.
start reading at page 15.
Oh, great. Then
But
I have no objections to them going back.
recent appellate decisions have chastised district court judges for not including them in the final set. So.
No problem.
Okay. Pages 15 through 23 are Muji second standard instructions without modification that were also part of the party's proposed instructions submitted prior to trial began. Take a moment. Take
No
a minute.
objection from the state.
No
Okay.
objection from the defense.
Okay. Ms. Nestor, pages 24 to 25 is the substance, I think, or is a Muji standard instruction regarding in custody informants. It would require maybe a little editing to remove some unneeded syntax.
Mm-hmm.
So first, I need to hear from the state about whether they have a general objection. And second, we need to make this specific, if it were given, to the time periods that Ms. Lober was actually in custody and the evidence regarding those periods, because she's not in custody during the time she's on the stand.
Right?
Your Honor, the state objects to this instruction because this is for a snitch. She's not a snitch. It's a different circumstance. Now, the defense has proposed an instruction.
From the 10th Circuit
Right.
Yes,
state, yeah,
Garcia
right.
instruction, which seems more nuanced for the circumstance that we're talking about. So if we have to have one, then that would be the one we would prefer, rather than this snitch instruction.
I looked at the case that is the genesis of this. That informant was in custody at the time of trial and came from jail to trial and from trial back to jail. And so I recognize that this case isn't that.
The other thing is, Your Honor, the witness credibility instruction number 20 from page 22 allows both parties to argue whatever they need to under this circumstance. I mean, the unique thing is there is the idea that she was given immunity or the testimony about immunity, as well as for Crozier. So that all is great for argument, but I don't know that we need any special instruction, given that neither person was in custody at the time they testified.
Ms. Nestor.
Your Honor, I think case law is really clear that witnesses who are either granted immunity or are bargaining in a jail setting for their own freedom when they give information, which is the circumstance with Ms. Lober, are a special category of witness. There are things that a jury can take into consideration that exceed what is contained in the normal witness credibility instruction. In this particular case, while I agree there may be some editing we need to do on the in custody informant, I think the importance of this is she was she was making a statement with the understanding that, that her freedom was contingent on it. And I think that this is an approved Muji instruction. I think I agree we should probably limit it. When I submitted it, I was thinking all her interviews, she was in custody. But I didn't think about the fact that
Agreed.
she's no longer in custody. I never really looked at this instruction that way. I always looked at it as of the time that they cut the deal. But I could be wrong about that. So I don't have an objection to adding dates that she was in custody if that is of concern to the court. I do think she made it pretty clear when she was here she wasn't. So I think the jury knows she's not currently in custody, but I mean, it doesn't matter. I'm fine putting those dates in. But I think the immunity one should be given in addition to this because the immunity agreement also covers federal immunity, state immunity.
Yeah.
I think we should get both. And we can just take out whatever on this in custody informant doesn't fit our facts. We can just jettison it. But we are asking for both.
Mr. Burmester.
Your Honor, a couple of things. First of all, if we're going to identify a witness by name, it should include all of them that come within the definition. So it's not just Carmen Lober. It should be
Understood.
Crozier.
The periods during which Mr. Crozier was giving the interviews, he was in
Yes.
custody, correct?
Yes.
Okay.
In fact, we saw
one
an interview
yeah.
with him in custody, in
Right.
stripes.
Same with Carmen Lober, right?
Yes.
Yeah. Okay.
And once again, this instruction is designed for the situation where the snitch doesn't know anything about the facts of the case, wasn't a witness to anything. They just happened to be a cellie or something like that. And that's what this was designed for. That is not this case. Both of them were witnesses to the things they observed. There was discussion about immunity, and for that reason, we object to this snitch instruction. And if we have to have something, then maybe either add to the witness veracity instruction or something along the lines of Garcia mentioned before.
All right. Let me think about this for a moment. Mr. Burmester, putting this instruction aside for a moment, any objection to including the 10th Circuit form instruction from Garcia?
I think the 10th Circuit instruction from Garcia is fine, but I think it's duplicative if you're talking about the snitch instruction as well.
I understand. And Ms. Nestor, I understand defendant's position to be the state should give both instructions properly edited.
Right. It is occurring to me, if the concern is There is a federal instruction that we often use when we have what are called unindicted co-conspirators, that are people that were actually involved that then flipped on whoever's didn't flip.
Provide helpful information.
Yes, sir.
Yeah.
I don't like that word snitch, but
Yeah.
that one may be closer to the facts of this case. I just than this one is. And I can pull that up really quickly. It's a 10th Circuit pattern instruction for unindicted co-conspirators.
I'll take a look at it during a break.
I'll submit it.
Okay. We'll come back to that.
Okay.
Okay. I've made some notes. We'll return to this issue at some point. Okay. Pages 26, 27, 28. Standard Muji second closing instructions. Any objection, Mr. Burmester?
No, Your Honor.
I'm sorry. Which pages, Your Honor?
26, 27, and 28.
I think you have the fact versus expert witness in here twice. I think you have it on page 32 as well.
That's entirely possible.
So I don't have an objection to it. I just think we need to only have it on once.
Yep. I will take it out of this position. I'll omit page 26, keep page 32.
Okay. All right. And then the presumption of innocence is fine. The reasonable doubt, I understand this is a Muji. I understand there's some litigation going on as we speak in other states, and in this state, it has been at least touched on that the language that that reasonable doubt is evidence which leaves you firmly convinced that the defendant is guilty of the crime charged. There is some real question if firmly convinced actually properly describes what reasonable doubt should be. I understand this particular instruction has been accepted by the Supreme Court, I think in case law and obviously in Muji. So I concede that but I would like to preserve that error because I'm not sure that's going to remain this way forever. And so we object to the language of firmly convinced as being not strong enough to describe what beyond a reasonable doubt is.
Okay. I understand. And the record reflects that the defendant is objecting to the definition of beyond reasonable doubt as evidence that leaves the jury firmly convinced that the defendant is guilty of the crime charged. The court notes that defendant's objection in argument is based on State versus Wall, 566 P3rd 833, paragraphs 51 through 55. On balance and based upon the current weight of Utah appellate court authority, defendant's objection is respectfully overruled. Anything further on that, Mr. Burmester?
No, Your Honor.
Okay.
And then what was the last one you went through, Your Honor?
Well, then we go to page 29,
Right.
which is not a Muji standard instruction, but is a copy and paste from the last paragraph of burden of proof from the opening instructions.
Yes.
I see no harm in giving it again. This is what you asked for, right,
Yes.
Ms. Nestor?
Yes. Thank you for doing that.
Mr. Burmester, any objection?
No.
Okay. Bear with me, folks. Let me just make sure my notes reflect what we've talked about so far. Okay. That brings us to page 30,
No
Muji
objection.
standard instruction.
No objection.
Mr. Burmester?
No objection.
Okay. Page 31 is the court's effort at a 404B instruction. It uses the structure of the Muji second 404B instruction, inserts the case-specific language requested by defendant. Mr. Burmester.
Your Honor, if the court is inclined to give this instruction, we would ask that it include all of the 404B non-character purposes, not just motive. But
Do you have any other non-character purposes for that evidence?
yes, Your Honor, like all but one or two of them, I think, can apply.
Well, but as I understood, the only reason And when I instructed the jury in real time, the reason I gave them was motive. You weren't,
Well,
was it also go to,
Can it go to
preparation?
identity, preparation,
I know it
intent?
can, but we tried the case. Is that why you admitted it?
Your Honor, I should probably speak to that
Yeah.
one. The answer is yes, and it's been throughout our briefing since, the entire motions in limine practice. We, argued for the admission based on motive, intent, plan, and preparation and identity. Those words are always lumped together in our briefing.
I know, and talismanically, but not necessarily with factual basis. And so help me out. If I'm going to tell them that they can consider them for those specifics, there's got to be a basis. Or we can say other purposes such as motive. The reason I'm coming back to this is I want to be as close to the instruction I gave them as real time as possible, which we litigated in real time. And I didn't say the talismanic words in real time. I said motive.
Yes, Your Honor, but I think the court said motive based on what the defense was requesting in the instruction. The state wasn't limiting the instruction at all.
May we say such as rather than all of those combined?
I'm sorry, could you just say it in a sentence?
Yeah, such as determining motive, preparation, plan, or identity. Or determining things such as motive, plan, preparation, or identity.
For the limited purpose of determining things such as the defendant's motive, plan. Okay.
Yeah.
Yes, sir.
Okay. Ms. Nesser.
Well, I think the court was right initially. I've never been under the impression identity was an issue in this case. I don't understand how any of these things would go to plan or preparation. I think the way it's written is correct. So I would object.
Certainly the first bullet point would go to preparation or plan. Plan, not so much preparation.
I just would like the record to reflect we object to it, Your Honor.
Okay, hold on a second. I'll just make a note of this. We'll come back to it. Okay, 32, 33, 34, 35, 32 through 36 are Muji's second standard instructions.
No objection from the state.
Your Honor, on 33,
Mhm.
the law enforcement officers, I think that should be plural, many law enforcement officers testified. So I think we have it in the singular right now.
Okay. You heard the testimony of law enforcement officers.
Yes.
Got it?
And then the rest, I don't have any objection to.
Got it. Will do. Okay. 37 versus page 38. 37 is the motive instruction that the parties proposed pre-trial. It talks about Kouri Richins' motives, plural, which is a little fuzzy regarding the law. Here, there are two aggravating circumstances. One qualifies as a motive, the other qualifies as means. The motive would be an element to the extent it's the aggravating circumstance. The means is an element to the extent it's the aggravating circumstance. In the abstract, if the jury were to find unanimously regarding the means, but were not able to reach unanimous agreement regarding the motive, there'd still be a basis for a conviction. So the the court proposed the version on page 38.
Can I clarify? I was with you up until the very end of what you said, but I think the court's probably right. Are you saying that the only thing that requires the motive is the subsection 1 of the aggravated murder, which is committing homicide for pecuniary gain?
Well, so if we go to the elements instruction, we just want to look at that together as an example. So go to page 41.
Right.
You could have 8 jurors that unanimously agree on elements 1, 2, 3, and then when it gets to 4, they're going to have to unanimously agree regarding one of the 2 at least.
Correct.
Now, they could unanimously agree regarding 4B without ever agreeing regarding 4A and without ever agreeing about a motive at all, just regarding the act.
I think that's right.
And so the way the parties had written it beforehand did not contemplate that possibility.
I think you're right.
I'm just not convinced that motive is coextensive with intent. And I think the state is required to prove it was the intent of the defendant to cause the death for the purpose of.
Yeah, the difficulty here is the pecuniary gain is a why, not a how, and why is motive.
Right, that's right.
Well, motive might be my financial situation is so distraught, I'm going to commit this murder. Or I'm just so darn greedy, I just want more money, so I commit a murder. I think motive might be involved in both, but I have to prove that was the intent to do it, was to make the money, whether you had the motive, this underlying thing or not. I don't know.
I believe intent goes to intent to cause death.
That is among the things that the jury would have to find unanimously.
Right. The pecuniary gain is clearly motive. That is a motive that they've alleged. And I agree that I think subsection B does not require a motive because it doesn't matter why she's administering the lethal dose, just that she is administering the lethal dose. And I think we just missed that in the one we submitted. I think the court's right that motive only applies to 4A. And so it's tricky to explain this to a jury without a side-by-side analysis of the elements instruction.
Now, another option, right, is just to not give a motive instruction.
That would probably be the best. Except that,
Because then we don't have to get confused about whether the why is part of 4A versus 4B. We can just not instruct regarding motive.
I mean, I do believe the motive is there in the elements instruction, whether we explain whether it's a motive or don't explain whether it's a motive, they still have to prove this. So I'm okay with no motive instruction.
If we take the motive instruction out, it kind of frees everybody up to talk about what they really mean.
Right.
Without having to thread the needle of what's an element and what's not.
Let's do that, Your Honor.
Yes.
Okay. Any objection, Ms. Nestor, to omitting a motive instruction entirely? A separate motive instruction.
I think it's just utterly confusing. It's going to confuse the jury. I think we should take it out.
Understood. Pages 38 and 37 are omitted. Okay. Page 39 includes definitions. In fairness, I'm not sure I got them all, so we may have to add some more in here as we go.
Your Honor, I think we've removed the domestic violence recitation, so the cohabitant and direct definition isn't needed anymore.
Yeah, it was unclear to me. It was a sentence that I read regarding counts 1 and 2 as part of the reading of the information, but we can take it out and just proceed as if it doesn't matter. What's the state's position?
I didn't know we pulled. Go ahead.
Yeah, Your Honor, I know we didn't pull it as, I guess we pulled it by agreement as an element of the offense, not as a sentencing enhancement.
Right.
So I think the status quo is the parties agree that if the defendant is convicted of counts 1 and 2, that there is the DV sentencing enhancement automatically.
Right. That's right. It goes to sentencing, not to
But
conviction.
don't we need the jury to specially find it beyond a reasonable doubt in order for me to rely upon it at sentencing?
Yeah, I think that was part of the stipulation, is that it is just a stipulation of finding.
Okay.
The court's going to be able to find that, Your Honor. They were cohabitants.
Well, I just need a waiver of Ms. Richins' right to jury determination on that, and then I can make the finding afterwards if that's how you want to proceed, or you can just stipulate to the fact now. I genuinely don't remember what we did with this prior to opening statement.
We do not want the issue of domestic violence in any way to be considered by this jury because it has not been addressed. It's too confusing.
Okay.
And in return for that, we agreed we would not challenge that they were cohabitants if the court has to be faced with determining whether or not there should be a sentencing enhancement for that
Okay.
at sentencing.
May I put it in my language and to see if you're comfortable with it?
Yes, sir.
Ms. Richins has the right to have a jury determine whether she and Eric Richins were cohabitants beyond a reasonable doubt. Is she waiving that right and submitting that issue to the court
She
for
is.
determination by the bench?
She is.
Okay. Ms. Richins, do you understand the rights you're giving up?
Yes.
Okay. Are you waiving those rights knowingly and voluntarily?
Yes.
Okay. I accept your waiver. Find it's knowing and voluntary. On that basis, I'll remove any reference to cohabitant throughout the instructions. Agreed, Mr. Bloodworth?
Yes.
Or Mr. Roberts, sorry. Ms. Nestor, any objection?
No, Your Honor.
Okay.
Okay, is this, Mr. Burmester, is this definition of attempt
Yeah,
the same as yours
that was added by the court before I ever
before you
got a
did this?
chance to ask and conclude it. It appears to be the same thing, so.
Okay, just one moment, Your Honor. Can I just compare something just very quickly on the
Yeah.
attempt?
We'll need to take a break, so put a pin in it if you want. And
It just will take me
Okay.
1 second. Okay, all right, so we can just toss this, right, Mr. Burmester? We can
Yes.
throw this
Yes,
out.
absolutely.
Okay.
That is-
All right. No objection to the rest of the definitions instruction, Your Honor,
okay,
or to number 40, which comes after it.
thank you. Mr. Bremer, is there any objection to page 40?
No,
All right. That brings us to pages 41 to 42. Elements of criminal homicide, aggravated murder, count 1. It is the italicized language that represents a addition or proposal by one party or the court.
So the italicized language included under number 4, the concern that I have in this case, and there may be a better way to deal with it than this, but I wanted to just bring it all out for discussion, and I'm not really married to how we address it. I think you know where I'm going with this. So there is testimony that has come in, or evidence, either testimony or documentary, that could let a jury find that Ms. Richins purchased oxycodone, thinking it was oxycodone, and it was actually a fake oxycodone that neither she nor Mr. Richins were aware had fentanyl in it. My concern is if the jury thinks that under that circumstance, it would be aggravated murder, which it would not. It would be a different offense, which is not charged here. It could be a lesser included offense. So I don't know how to carve out. It's my reading of this statute and the information that in order to convict Kouri Richins of aggravated murder, which is this count, they have to believe that she knowingly and intentionally caused his death. If a jury is confused about whether knowingly and intentionally causing someone's death means buying something you think is oxy, giving it to someone and it's actually fentanyl and they die, that's a problem.
Well, pause for a minute. Let me ask you some legal questions.
Right.
So I acknowledge that I think you tell me.
Okay.
I'm learning about this in researching these instructions and seeing your proposed language.
Right.
Assisted suicide manslaughter is a crime with specific elements in the state of Utah, right?
Right.
Under 76-5205.
Right.
If, for example, a defendant in a murder case wanted to request a lesser included offense based on this factual theory, they would have a basis to do so because that lesser included exists.
Correct.
That's not the same as saying, though, the state has to disprove that alternative beyond a reasonable doubt. It's not an affirmative defense.
Right.
I agree with that.
So I don't think I have to include that language in the elements. The real question is whether you're asking for a lesser included or I mean, you could certainly argue to the jury some
That's-
factual inference that,
Yeah.
listen, there's an inference to be drawn here that she got this stuff for him because he wanted it.
Yeah.
You know, that line of reasoning or doubt.
So
But I don't think the state has to affirmatively prove without a reasonable doubt that this isn't assisted suicide manslaughter.
So I think that the state has to prove it was a surreptitious administration. And I don't know how, I don't think it's enough if she administered it by handing it to him and he said thanks and ate it and died. So I don't know how we address that with the jury.
Does that follow from the elements in the statute?
It says by the administration of any substance, and it doesn't say, I just don't think that's aggravated murder. If she administers it by handing it to him and he says thanks and eats it, that's not aggravated murder.
Well,
Even
here, I'm going to create a very morbid and dark hypothetical.
This is all morbid and dark. So.
Imagine a healthcare provider
Right.
says to a patient, would you like some morphine to help with your pain? They say yes, and then pushes the plunger way too far intentionally. I think that's
there's an
still
intent to
aggravated
commit. That's an intent to cause
to
death,
cause
though.
the death. Yep.
Right. But we've got witnesses of the state coming out talking about you can be fooled by these pills. I mean, they put that testimony
Yeah,
on,
but that's
right?
a different element, right? You're down on 4B. I mean, I'm down on 4B. Intent to cause is up on elements 1, 2, and 3. We're talking about the how, not the intent. The intent as to the result is the top level. That's homicide. It's the aggravating circumstance that's 4B. Let me pause there. I'm carrying a lot of water here. Does the state see it the same way?
Yes.
Okay.
Yeah.
And Your Honor, this, from reading the tea leaves on how the facts came into evidence in this argument, the state is concerned that the state is concerned that the defense will not be precise in arguing the intent in closing, right? The evidence has come in, and this discussion here today has suggested that the defense is putting the intent on a specific drug to kill, and that's not where the intent lies here.
No, but would you acknowledge that if the defense were able to persuade the jury, for example, that Kouri Richins intended to give her husband a non-lethal dose of hydrocodone, that would be a permissible basis to argue that she is not guilty of aggravated murder.
That is a permissible basis to argue she's not guilty under the second element of aggravated murder.
Why not the first, second, and third? She didn't intend to cause his death. She intended to give him non-lethal painkillers.
Well, okay, second and third together.
Yeah.
You know, we split them up here sometimes. They're in the same sentence. It's really weird that we split them up.
Right.
But the second and third together,
Right.
Sure, that is fine. But intent is not an element of 4B. Like in
Agreed. Oh, I agree.
I actually agree with that too. I was just trying to figure out how to deal with this scenario and not have a jury. I guess we'll just focus on intent in the argument.
Yeah, it's intent to cause a death, intent to cause a result. That's where the intent lies. If you intend to cause the result by means of administering what you think is fentanyl and it turns out to be hydrocodone and it's deadly either way, doesn't matter. Or vice versa.
Right.
Yeah.
If you intended for the end result to be to die.
Right.
I agree with that.
I think we're all agreeing.
I agree with that.
Okay. Can we put 2 and 3 into one sentence?
We can. We typically don't, Utah, because we want to make sure they separately, unanimously find beyond a reasonable doubt the culpable mental state.
I also think there needs to be a separate finding of causation. I think they should be apart.
So, I mean, this is the way the elements instructions under Mucci typically work.
Yeah.
It's confusing.
You can send a strongly worded letter to the Mucci committee, but I'm going to stick with this for now.
Yeah.
But we're going to strike. Let's just go down the page here. Mr. Burmester, did I cut you off there?
No, Your Honor.
Okay. We're going to strike the language without the knowledge or consent of Eric Richins because the court rules as a matter of law that that language does not represent an element of the crime or an affirmative defense that the state has to disprove beyond a reasonable doubt. Okay. Then we get to the extra italicized language of which I've provided two versions. One more elegant than the other, and the more elegant one isn't mine. But rather than have a separate instruction for jury unanimity, one offense in 2 ways, I thought we'd just include the operative language here. And all we need to do is expressly instruct the jury that there are multiple ways to find that this was committed beyond a reasonable doubt, but you've got to agree about which one of the 2 aggravating circumstances you believe the state has proven.
That's 100% the law. That is correct.
Yes.
You're right. Because I was going to say, I thought we did this, but you're right. We put it in a separate instruction. This is much better to put it in the element instruction, I think. I like it better.
With all, I mean, let's be clear. This was Melanie's idea.
Yay, Melanie.
Yeah.
Yeah.
So we're talking about the top.
So you've got
A and B,
you got
right?
2 options here, right? You got the more wordy option before the or the more elegant version after the or.
I think the top one's clearer. Even though it's longer, it's clearer.
Oh, you're right. I'm sorry. We'll put reason instead of motive in there. Good catch. So, Ms. Nestor, if we were to see in the top version, instead of saying for the motive of pecuniary gain, may we say for the reason?
Yes.
Okay.
And I think you also have motive
In the very beginning.
in the first sentence.
Yep. The reason or means. You know, as we do this, though, I'm kind of leaning towards the second version.
Your Honor, the state does too. I also think we need to account in the second version for the possibility of finding both. I mean, you say at least one,
Right.
but there, I think the next line, and you must unanimously agree which circumstance, I think we parenthetically plural it.
You want to say which or both?
Yeah, something like
Okay.
that. The state has proven.
Yeah, we can do that. Do you want to say which circumstance or circumstances the state has proven?
Yes.
Or just put a S in a parentheses, like, so it could be either.
What's that? Yeah. We'll just say which circumstance or circumstances. We're going to go with option 2, Ms. Nestor, notwithstanding
Okay.
the time I wasted on option 1. Okay, pause there for a minute. I'm just going to read it out loud. You tell me if it hits the ear correctly.
Okay.
To find the defendant guilty of aggravated murder, you must unanimously agree the prosecution has proven at least one circumstance listed in element 4 beyond a reasonable doubt, and you must unanimously agree which circumstance or circumstances the state has proven.
Okay.
If you find the defendant guilty of aggravated murder, you must determine, we'll get rid of that
Yeah.
sentence. Got it, thank you. And we'll just keep you, we'll mark your decisions on the verdict form. Okay. Ms. Nestor, anything else there?
Just a moment. I'm getting a text. I just want to make sure I'm listening to my co-counsel here. That's fine. Okay, no, that's fine, Your Honor.
Okay. I will make similar changes to the elements of count 2. So we'll get rid of the italicized language in element 4. We'll strike the inelegant option 1, and we'll get rid of the reference to cohabitant. And then we'll add the or circumstances.
Okay.
Okay. With respect to the definitions of mental state, murder is homicide is one of the rare crimes where it is a result-based crime, not a intent or action-based crime, right? Notwithstanding your best efforts, if you don't kill someone, you did not commit homicide. So the mental state definitions have to be specific to counts 1 and 2, and they are different, I think, than counts 3, 4, and 5. Is that the state's view of it?
It's certainly with regards to 1 and 2. One would think this is a super easy thing to figure out if
It is
something
not.
is specific or general intent crime.
Yeah.
And I've struggled with it for 30 years. Maybe that indicates I'm stupid. But I have no objection to proceeding with the way the court is laid out.
Okay.
Right,
The
'cause
mental state's definition on page 46.
right. I think initially the ones we submitted, Mr. Burmester had actually put it on the bottom of the counts, and it was, I like this better, separate. I don't know. I always question whether jurors ever understand this, but I think this is the best shot we have at getting it to them.
Yeah, in fairness, I should probably move mental state to find counts 3, 4, and 5 to after.
After you
The
give the
elements
elements instructions, I think
So-
that would be better.
But while we're there, Mr. Burmester, I understand you to say no objection to pages 45 or 46. Is that correct?
Correct.
Okay, Ms. Nestor.
So you're going to move what's on page 46 behind the elements instructions for 3, 4, and 5.
Correct.
That's better, I think.
Okay. Any other objection?
Just 1 second, Your Honor. I think this is the same language we had. Yeah, no other objections to that.
Okay. questions regarding elements of 3, 4, and 5.
Yeah, so do I.
So I got to pull the information. We got to look at the statute. Bear with me for one moment. Melanie, I'm not ignoring you. All right, so let's focus on count 3 for a moment. It's insurance fraud, allegedly committed somewhere between January 29 and August 31. It is charged under Utah Code 76.
Here's your charging.
6, 521.
D.
2D, right?
Yes.
All right, so let's start with a couple of my mental state. Because the statute does not specify a mental state, it's intentionally, knowingly, or recklessly, correct?
Well, it says it specifically in Part D.
Oh, with the intent to deceive or
It's
defraud.
a specific intent.
Oh, there we go. Yeah, so this is where it gets confusing because 2 says with intent to deceive or defraud, and then 2D says intentionally, knowingly, or recklessly devises a scheme. So different intents for different parts of the elements, right?
Yeah, okay.
Okay.
Yes.
Devises a scheme or artifice to obtain ... anything of value by means of false or fraudulent pretenses, representations. So 2 questions here. I don't see from an insurer anywhere in the statute.
Agreed.
May we strike that language?
Yes, from the state.
I mean, I don't want to add language in, so
Okay.
that's fine.
So we'll take that out. And then Ms. Nestor, in your submission this morning, you make reference to 2D's
Right. Let me pull that.
phrase, fees for professional services.
Right. So I read this statute differently than the state does. I think they're trying to shoehorn a crime that is a different crime under the statute. I think if you read the plain language of the statute, taking out fees changes the whole nature of what this crime is. I think this is actually not the proper crime that they meant to charge, but now that they've charged it, I think they have to do it as written.
Well, tell me why subsection 521 2D doesn't read as follows based upon its plain language.
Hold on, Your Honor, can you give me 1 second? I had to pull the statute up on my screen.
No problem.
Just let me catch up just a minute. There's something going on here. All right.
Excuse me.
Okay, there we go. All right, just a minute, Your Honor. 76 6 521. Here it is. Okay, I'm with you. Please continue.
All right, so 521-2, an actor commits a fraudulent insurance act if the actor with intent to deceive or defraud does one of a number of things, but as relevant to this case, D, intentionally, knowingly, or recklessly devises or scheme or artifice to obtain 2 categories of things in the alternative: fees for professional services or anything of value, and then by certain means. Why doesn't it apply equally to 2 alternative categories of things?
I read that differently.
Okay.
And this is the fun part about, plain language, right? So I read it to say that this is the crime for when someone is pretending to be like, to get fees for selling insurance fraudulently. That's what I think this section of the statute is. And I think the fees part applies to, it should be read to obtain fees for professional services or anything of value. In other words, I'm trying to get someone to pay me as an insurance broker by making false representations about what I'm selling you. I'm selling you something that's junk. It's not what you think I'm selling you. So I'm either trying to get a fee or have you pay me for the actual product that I'm selling you, but by means of lying to you about what it is I'm doing for you. That is what I think this is. And that is not what anything to do with Ms. Richins. I think they liked that second half of that and pretended like the first half didn't exist. And that's how I read this crime, because that is a crime. There are people that go, I've represented them. They go around and they sell junk. They sell a policy that doesn't cover anything. And they get either a fee from you as a broker, or they get a commission, which from selling you, they get a commission of the junk product. And it's fraud. And that's what I think they're talking about in this crime. And I don't think it applies here. And I want the word fees in there because I think they picked the crime. They got to prove it as it's written. And they just deleted that word.
Well, they're not proceeding under that theory, but it's in the alternative. I have to acknowledge the comma and then the word or.
Mm-hmm.
And I can't consider the word insurance in the title of the section. That's non-substantive. In fairness, I see that the word insurance appears in section 2. So I understand. I'm looking at the definitions, though, for the part and the definitions in 101.5, and they don't define insurance. And the legislature's got to call it something. They chose to call it this. This seems analogous to the statute for communications fraud, which really is fraud. Like the communications and the communications fraud isn't doing much besides requiring that somebody communicate something by speech, writing, whatever. I too wrinkle my brow at the inclusion of the word insurance, but it seems just to be a label that the legislature has used. The substance of the statute on its face says what it says. Are you aware of any reported decision limiting the scope of this statute?
I tried. I looked. I couldn't find this particular, because I just kept reading it over and over. And I'm like, this is what you charge brokers with. This is what you charge, scammers in the insurance industry with. That's this crime. And I object to taking any words out of it exactly as it's written, because I don't think they proved this. And I actually think they charged the wrong crime. I don't think that applies to the next two, but I do think it applies to this one.
You'd acknowledge that even if we put it in, it'd be an or.
Well, depends how you read it. I mean, if you take out the words or anything of value, or
No,
it doesn't
I
make
wouldn't
sense.
take those out.
No.
Yeah.
I'm saying for
Yeah.
purposes of trying to understand it in context, right? So like the initial part of this says intentionally, knowingly, or recklessly devises a scheme or artifice to obtain fees for professional services, comma, or anything of value. And their reading of that is that or anything of value goes back to a scheme or artifice to obtain. But I don't think that's right. I think it goes to either for professional services as their broker or anything of value, like you made them buy a product from you. And so I think they should have to say exactly what it says on here, and the jury's going to just have to figure it out. But
Okay, but even in your world, in your view,
yes,
I hear you saying it would be 1, Kouri Richins; 2, with intent to deceive or defraud; 3, intentionally and knowingly or recklessly devise the scheme or artifice to obtain
fees for professional services.
3A, fees for professional services, comma, or 3B,
But that's,
anything of
That's not
value.
that's not how it's written, though, Your Honor.
It's exactly how it's written. I
No,
just
it's-
put the comma and the or in the same place.
No, you put a B in there, an A and a B, and I think it's all connected. I don't think it's written that way.
Oh, okay. Well, then we should take the 1, 2, and 3 out as well.
Take the which
Never
one?
mind. I understand your point.
Yes.
Okay. Mr. Burmester, go ahead, sir.
If we're going to add the theory that we're not proceeding under, then it should be A and B to make it clear, because it is an alternative. It's a list of 2.
It's,
I don't know how to read it any other way.
If that's wrong, it comes back though, because that's not. These go straight to elements.
Okay. So, Mr. Burmester, any objection to including the language in the alternative form as it exists in the statute?
As long as it's A, alternatively A or B.
Okay.
I object to the A or B, Your Honor. I think it should be all one sentence, like exactly like it's written.
I understand your position. Okay. Let me give that some thought.
Your Honor,
Mr. Ramos, go ahead.
just as you're giving it some thought, and I'm looking at 76.6521, just straight from the code. An actor commits a fraudulent insurance act. I had missed it on, Your Honor probably didn't miss it. I missed it on the first one, but going back to the insurance act, that isn't in the instructions as it currently is, but just highlight it now as Your Honor looks at that.
Okay. Thank you, sir.
Thank you.
All right. Very good. I've got a note there. We'll keep going. Regarding count 4, I didn't see any disagreement between the parties regarding the elements for count 4.
No disagreement, Your Honor.
Mr. Burmester.
Did we talk about element 4 of count 3? Because I'm not sure where that came from.
Oh, thank you. Yeah, you're right. I went too fast. I don't understand where that came from either.
I'm sorry, what? I didn't understand what he said.
Paragraph 4 of the elements on count 3
on
page
count 3.
47.
I'm sorry, I got to go back. Just 1 minute. I thought we were on 4. Okay, element. Oh, took a substantial step. That came from case law. That's case law.
Have the citation.
I did on the one that I filed. Let me pull that up, Your Honor. Just a moment. It's document 1584 on the docket. And wait a minute. Count 3. This was a different one. Let me see. I might have written it in my notes to the state. Just a moment, Your Honor. Oh no, I don't think that came from me. I don't think that came from me.
It did not come from the state.
I think it did. I can go back to what you emailed or from the parties and was represented as, but it's not in the statute. neither is the definition of insurer, and neither is the definition of substantial step. That's why we have highlighted.
Oh, I
those.
know where this came from. Mr. Bloodworth and I had a discussion about the fact that the way that it was originally written, she wouldn't have had to do anything. She could have just imagined it and never taken an actual step towards the commission of the crime. And that language got put back in after we had that conversation. I think, and we were trying to fix that problem. And I think that was what Mr. Bloodworth added to fix the problem. I was the one that originally said the way it's written, she could just think about it and be guilty. She wouldn't have to do anything.
I think an act is kind of implicit in 3 by means of false or fraudulent pretenses, representation, promise, or material omission. I think that's the act here.
Well, I understand the point. It seems that the actus reus under 521 2D would be the devising the scheme, which I think is Ms. Nestor's point.
Right.
Of, well, if you devise it,
I could think of one right
never
now.
say anything,
Right.
do anything, have you violated the statute?
Right.
So what is the actus reus? What's the conduct?
By means of, and then those,
Well, but that's just a modifier on the scheme
Right.
that you've devised. I think the operative verb there is devising.
I do know in federal court law, it's clear you have to take a substantial step. I don't know if they just have an objection to the word substantial, but you got to do something. Something has to be done other than thinking of it in your head.
Why don't we just instruct regarding what the state's theory of the crime is?
Right.
And either they proved it or they didn't beyond a reasonable doubt.
That would be fine with me.
I mean, forgive me, count 3 is I get confused between count
It's
3
the
and 4.
scheme one with the $100,000 two-stage policy.
Yeah.
by the end of the application.
Yeah, the fraudulent, false or fraudulent pretense.
It's the submission of the application with the fraudulent stuff on it, right?
It's the submission of the application, but it could also be
Just signing
filing
it.
the claim as well. But yeah,
Okay, sure. Yeah. You could, yeah. You could, we could instruct the jury that the state's theory is that Kouri Richins committed this crime by A, B, and C. I give it,
Or-
yeah, right, yeah. We'll take a break. You can all give that some thought, maybe talk to each other. I understand your concern. But it seems that we don't need to be coy. We can just tell the jury what the state thinks, and either the state proves it or they didn't.
Yep.
Okay, give that some thought. Okay. In terms of our initial review, let's keep going. Elements of count 4. Just read through that for me for a moment. Let me know if anything sticks out.
This I don't have an objection to, Your Honor. I think this tracks the statute and it also tracks the case.
Okay. Mr. Burmester, let me know when you've reviewed it.
On 4?
Yes, sir.
No objection. Sorry.
That's okay. So then let's look at elements of forgery, count 5, 76-6-501. 2B1. An actor commits forgery if, with purpose to defraud anyone, or with the knowledge that the actor is facilitating a fraud to be perpetrated by anyone, the actor makes, completes, executes, authenticates, issues, transfers, publishes, or utters any writing so that the writing or the making, completion, execution, authentication, issuance, transference, publication, or utterance purports to be the act of another person, whether the person is existent or non-existent. This is the signing of the true stage life insurance application, signing of Eric Richins' name allegedly to the true stage life insurance application. Correct, Mr. Burmester?
Yes.
Okay.
Oh, there it is. Got it.
So we've got to keep with purpose to defraud anyone in there, right?
Yes.
Out of paragraph 2.
Yes.
Okay. But then I think if I understand what you submitted correctly, you're asking for without the authority to do so.
Right. That's right. And
Okay.
that's I decided the case law on that, state versus Gonzalez, state versus Collins, and I think the state has agreed to that.
Is that correct, Mr. Burmester?
Yes, Your Honor. That's
Okay.
an element that
Very good. So
supported by those cases.
2 and 3 stay in, correct?
Yes, sir.
Yes.
And then do we need to, can we skinny down 4 in any way to match the state's theory? Or
I don't know.
it's
if
just
we
the
have
way it goes?
authentication.
I mean, execute and authenticate don't really match the facts of the case.
Isn't execute just sign?
Yeah, because I thought execute meant make it effective. Like, I don't know. And authenticate usually means notarize or something like that. I still don't know what utter means.
Well, we can go back to page, any intentional act that puts a writing into circulation and implies by word or action that the writing is genuine.
I mean, it just seems like you could say make or complete a writing, or just make a
I think it's
writing.
make or utter.
Yes.
Make
That's
or
what I
utter.
think.
Utter's a weird word. Makes me think of a cow.
Mr. Burmester, make or utter, or make, execute, or utter?
Either of those two alternatives are fine for the state.
All right. Court rules that paragraph 4 should read, did make, comma, execute, comma, or utter a writing so that the writing or the making, execution, or utterance purports to be the act of another person, whether that person is existent or non-existent. Do you want to take out the last clause?
I mean, we're dealing with an existent person, so
At the
it
time,
seems
yeah.
kind of pointless.
Any objection, Mr. Burmester?
No, Your Honor.
Okay. Got it. Thank you. Okay, pages 50, 51, 52, 53 are Muji second standard instructions.
I agree with that it is 50. But, this certainly doesn't preclude one from arguing where two charges might be related factually.
No, certainly not. The state in its closing can start with count 1 and then pivot to saying you can consider the strength of the evidence regarding count 1 as part of your consideration of count 2.
Okay, I just wanted to make sure we're
What
not.
we can't let the jury think is that if they find a defendant guilty of aggravated murder, well, screw it. We're just going to click guilty on the rest.
I totally understand the rationale for it, but
Okay.
as I read through it, I
Yeah.
was kind of concerned.
Okay. Page 54 is a edited version of what would normally come after as the second paragraph of page 53 to reflect that this verdict form has a lot more blanks than just 2.
Okay.
I'll take a look. You will see, please, the verdict form is separated into, I'm just going to say several sections.
To several sections.
Yeah,
Okay.
one section for each count charged. objection, Mr. Burmeister?
I couldn't understand what you said.
No problem. In the jury room, you will receive a verdict form. Please read the instructions on the form carefully. The verdict form is separated into, it currently says 2. I'll edit it to say several sections.
Okay, no objection.
Ms. Nestor?
No objection.
Okay. 55 is a Muji standard instruction. Any objection, Mr. Burmeister?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
56 is a Muji standard instruction. It was part of the party's proposed inclusions pre-trial. I'd like to hold it in reserve so I at least have a place to start if the jury reports that they're having trouble reaching consensus.
Well, I just don't see the harm in doing, I mean, I think I always want jurors to be instructed by the court, not just us, that they're not to surrender their honest conviction as to the weight or effect of the evidence solely because of the opinion of their fellow jurors or just to return a verdict.
I agree. And that's why you should look at paragraph 3 on page 51.
Oh, okay. Did you stick it in there? I didn't see it.
No, it's just part of the standard overarching unanimity instruction.
Oh, that's fine.
I recently had a hung jury. I need a place to start to apply gentle pressure to keep working. And this is something I'd like to have in reserve. Okay, so I'm not going to give this as part of the pre-closing instructions.
There is a typo on it.
I'll fix it. What is it?
Third line from the bottom, do not surrender.
Thank you. Got it.
It's kind of an important section.
Okay. All right. May we please, and Ms. Nestor, we're going to come back to your submission here before I take a break.
Okay.
But let's go to the verdict form next.
Okay.
Fairness, this was the last thing I did before I came on the bench, and so there may be some typos or flow errors here, but let's just go through it one at a time as if we were jurors answering it to make sure that it flows correctly.
Okay, give me just 1 second, Anna. I'm sorry.
Your Honor, I don't, well, unless it's at the beginning. I don't think I got a copy of the verdict.
I think it was in the email that I sent after I sent a copy of the jury instructions.
I did not receive that email.
Hold on, Wendy, I'll send it to you right now.
That is entirely possible.
Thank you.
No, you did. Or at least I sent it.
I didn't get it, but
Let me forward it.
maybe just resend it.
Yeah, I'll send it right now.
Thank you.
Okay. I just sent it.
I should say skip to count 2.
Oh, we're going to take out 1B. And so this has to change to right there. 2. So I'm going to take out 2B. Okay. Okay.
Concerned that other mental health.
Oh, if we include it. Yeah. Okay. So let's see. Let's start with you, Ms. Nestor. So we'll take out the plural of inquiries and we'll say skip to count 2. There'll be no reference to 1B. We'll just omit inquiry 1B, right?
Right,
Same for count 2, similar changes.
right.
Any other changes?
Yes, so I have some worries about it not being, I know we have an instruction on it that's separate, but I sure would like it to be clear on the form of the verdict about that it has to be unanimous as to each one.
Doesn't it say unanimously regarding each one?
It does, but you could be saying you unanimously agree.
Oh, I'm sorry. Are you under 1A?
Yes, sir.
Okay.
So let's say they checked both.
So rather than say check all that apply, if I put in parens, check all regarding which you unanimously agree.
That would solve it.
Okay.
That would be, that takes care of my concern. Because my worry would be they would mark them both and we would never know that they were unanimous on each,
Okay.
or if they split it half and half. Does that make sense?
Yep.
Okay.
Any
No,
objection, Mr. Burmester?
No,
Mr. Ramos, my apologies. Go ahead.
No, I apologize, Judge. I jumped the gun on the ball. Just for flow sake, right under guilty of aggravated murder, the in parentheses, I would suggest flipping those. So starting, if you mark not guilty, proceed directly to count 2, and then
Sure.
after that.
That's fine.
Actually, that does make more sense.
no objection from the state.
Got it.
Same on,
Remains consistent with the,
and same under
Earlier
count
question.
2 as well.
Got it. Okay. Then, before we take a break, Ms. Nestor, may I go through just what you submitted this morning to make sure I covered it all, at least initially?
Yes, sir. Let me grab it just a moment. Okay, I'm ready.
All right, we handled the quote without the knowledge or consent of Eric Richins
Right.
language on the record. Changing her to there, I didn't see a spot where that would be a problem in these instructions, but
I think that only applied to the ones when Mr. Burmester had the definitions under the elements. I don't think it's
Oh, okay.
a problem anymore.
all right. 3, insurance fraud. I understand your position, and I'll take a break and make a ruling on it.
Okay.
The forgery elements instruction, I think we've reached consensus regarding anything further there.
No, sir.
I've ruled on defendant's request for a different definition of what constitutes proof beyond a reasonable doubt. Any further record there?
No, sir.
Number 5. Why don't you have sufficient foundation pursuant to the witness credibility instruction on page 22 to make exactly this argument? I'm not sure this is a legal instruction so much as a strategically sound part of your closing argument.
I think the Portuondo v. Agard case opens the door for instructions like this. I do think there's nothing in the witness credibility that talks about this. And I believe in Portuondo it was used against the defendant, but I think this is an interesting issue. I mean, if you have a witness who has sat through trial and heard everybody's testimony before they take the stand, that gives them an edge. And I think a jury can consider that. And I don't think there's anything in our existing witness credibility instruction that addresses something like that. And I think we have a right to bring it to their attention and say, hey, if you want to consider that, you can, but you don't have to. And that's why we want that instruction, because O'Driscoll was the last witness of the case. He had some very important testimony in this case, and he had the benefit of hearing 45 witnesses before himself and all the court's rulings on everything before and every out of the jury conference and everything. So I do think that's proper, and we are asking that it be given.
Mr. Burmester, I certainly understand why defendant wants the instruction. Anything further on whether they're entitled to it?
The state disagrees they're entitled to the instruction. Portuando didn't involve an instruction. It was exactly that an argument was made by the prosecutor about the defendant being present, and the court said that's just fine. That can happen in this case, but it shouldn't be an instruction from the court. It shouldn't. There's no basis for the court to give its imprimatur on O'Driscoll's veracity.
And,
Okay.
and can I just, before you
Sure.
rule, Your Honor, I am fine if you want to just take some semblance of this language and insert it into the witness credibility so it doesn't seem to highlight, as it being more important than any other thing they're supposed to consider when they're considering witness credibility. It's just one of a list. I'm fine with that too. So
Okay.
if that makes you feel more comfortable, I would do that as well.
I will, with the benefit of counsel's argument, take a fresh look at Portuando versus Agard. After the break, give you a ruling.
Thank you, Your Honor.
Okay. I understand defendant's position regarding United States versus Garcia. Anything further?
No, Your Honor.
Mr. Burmester.
I just want to reiterate that Garcia closer fits this than their point number 11.
Understood. We took out the defendant testifying instruction. That's handled.
Right.
We took out the children testifying and the age of witness instructions.
Okay.
I've given the request for a re-emphasis of the burden of proof instruction. We have a 404B instruction. I need to just make a ruling regarding whether we'll be discussing motive as the other purpose or motive, plan, preparation, identity.
Right.
The other 404B purpose is listed in the rule. I'll come back on that. And then we've already discussed the in custody informant instruction. I'll give you a ruling on that in a few moments. Anything further on that, Ms. Nestor?
No, Your Honor.
Ms. Nestor, anything further before we take a break?
The spoliation instruction.
You made reference to it in an email.
Yes.
Spoliation is a legal doctrine that has elements.
Yes.
You got to make a showing.
Yes. I understand that.
Okay.
Do you need a break, or do you want to just do it?
Let's
knock
take
it
a
out?
break while you
Okay.
get that lined up.
Okay.
But like some other rules, just saying the word doesn't necessarily get a party there. There has to be a showing. I have to make findings.
I understand.
So, all right, Mr. Burmester, anything before a break?
No, Your Honor.
Okay. 3:15, folks, please. Thank you.
Okay. I mean, I was hoping this would be like just a really short break, but apparently it's not. Let me just. Whoops. Hold on one second. I don't know. I mean, I really don't know what to do. I'm just so bored out of my mind with this. I may end this. I'm just like, I'm having trouble keeping awake in this charge conference. Let's see. No, we're still on a break. I mean, I'd like to have a record of the whole thing, but boy, is it boring. I mean, I thought I thought it got slightly interesting. Slightly interesting when they started talking about reliable witnesses. And oh, and then they said, and then the defense made it clear that they're objecting because Detective O'Driscoll got the benefit of hearing the other people testify. I thought they were going to be talking about Carmen Lober being unreliable. I was like, that's the best thing you have is Robert Crozier, the drug dealer, and Carmen Lober being crap witnesses. That's the best thing you have. So of course you're going to want to exaggerate that for the jury or bring the jury's attention to that. But no, it's about Jeff Driscoll listening to other people's testimony, and it's the case law that they're basing it on doesn't really even apply. But I'm losing my mind with boredom during this. So I don't know. I'm struggling. If it goes on like super long, I may end it early because I can't. If I can't stand it, I can't expect my audience to be. Yeah. Tater was like, "I'll see you later." I don't blame you, Tater, even if you had something to do. This is dreadfully boring. But I would like some kind of record of it. Because what Court TV tends to do is they'll keep things up for a couple years and then they'll migrate it to their website and you never see it again. Because they do so many trials, ditto Law and Crime. So it's nice to have a record somewhere of it. How's everybody else feeling watching this? Is everybody else as bored as I am? See people talking about the weather. That's not a good sign. I think we have, 85 people watching total? We've been going for about 2.5 hours. I find it interesting. Maestro finds it interesting. Yeah, I'd like to keep it open for the people that are interested, but I'm struggling. I like to be honest with my audience. I'm struggling. I know. I was saying, Maestro, that my friend Tony Talley loves charge conferences, and loves the jury selection, which I love neither of those parts. Jury selection I find slightly more interesting, depending. Charlie Adelson's jury selection was fascinating. I thought. You've been too busy chatting? Okay. I'm just wondering where everyone's at on this. I'll keep it open, but I can't say I'm going to be, I have a lot to say about any of these. I mean, she's facing charges for aggravated murder, attempted felony aggravated murder. So felony aggravated murder, attempted aggravated murder, fraud, and forgery. But there's so many different little elements in there. So we'll see how it goes. Just looking at just the reaction from the general public, I'd be shocked. She hasn't had any kind of innocence fraud campaign. The media hasn't been piling on with sympathetic stories about her. So I can't imagine her getting off with this, but who knows? I mean, the issues with the case are we don't know how she gave him the fentanyl. And there's no traces in the house of fentanyl, unless you're looking at Eric Richins' stomach, who was found in the house. I mean, if she gets acquitted and if we hear from the jury that we couldn't put the fentanyl in her hands, then I'm going to start getting worried about human beings and their ability to deductively reason. I think we need Georgia Kappelman to come give them a lesson in deductive reasoning and circumstantial evidence. I mean, a good example of this use of circumstantial evidence is if you see that the streets are wet, that puddles, cars wet, etc., you think it was raining. Now, a defense attorney would say, well, how do you know that there wasn't a movie set simulating rain on that street or whatever? But with the absence of any of that evidence being shown, you can conclude that it rained. You didn't see it rain, right? But there are clues. So this judge, I think, has been described by people in my audience as a real law geek. It's definitely the kind of judge that you want to have that's going to really apply the law. He's been battling it out with these defense attorneys through most of this trial. This is a great time if I had a Kouri Richins song to play it. I know other people have written them. But I mean, how long does the judge need to make a decision? I guess this is a complicated one. All right, I'll be listening. I'll be around and listening. I'm watching, listening, keeping an eye But I don't really have all that much to say, except I find this kind of stuff challenging. All right. Making an executive decision. We'll go over this maybe at 9:30 on Monday. Oh, whoa. Is it going? Did it get stuck? I don't know. I'm making an executive decision to close this down. We'll go over it Monday morning with closing arguments, maybe. Yeah, I think so. I'll make sure we do. Have a great one, guys. I just can't expect you guys to watch if I'm bored.
Mic check, Roberta strides through the static haze. True crime Gotham where the shadows play their plays. Fraudsters fold when a spotlight beams. Fact focused queen busting propaganda schemes. Glass shatter lies echoes through the streets. Standing for victims, giving voice their beats. NYC Pulse, truth sharp as night. Roberta exposing, she's the anti-fraud light. Hard cash warrior, dissecting state and defense. Twisted innocence, claims breaking pretense. Gotham's truth seeker cuts clean with the blade. Facts in the forefront, no justice gets swayed. Cold facts drip heavy, real talk unfurls. Cracking cases open like oysters with pearls. Innocence gimmicks crumble to dust in the wind. For victims, her creed, justice till the end. Headphones blazing, she drops heavy artillery. Narratives twisted, meet blunt object civility. Roberta got receipts that unravel the ploy. Exposing the lies these fraudsters deploy. Glass shatters lies, echoes through the streets. Standing for victims, giving voice their beats. NYC Pulse, truth sharp as night. Roberta exposing, she's the anti-fraud light.